Have you ever stopped to think about what could happen to everything you worked so hard to build? If you repartner or remarry and things don't work out, and maybe even more importantly, what would happen to your assets if something happened to you? Today, more women in Australia are separating later in life, rebuilding financially, and then finding love again. And while that's a beautiful new chapter to step into, the financial risks are often overlooked. Hi, my name is Helen Nan. I'm a certified finance planner and author of a finance book. The information I'm sharing today is general advice only, not personal advice, so please make sure you read the full disclaimer below. In this video, I'm going to talk about how women can protect their assets when repartnering or remarrying using binding financial agreements and proper estate planning, with real-life examples you can easily relate to. After separation, many women are in a very different financial position than they were earlier in life. You may have settled a long marriage. You may have received a home or savings that you simply can't afford to lose again. You may have less time left before retirement, and you may have children from a previous relationship that you want to protect. Under Australian family law, assets don't automatically stay yours just because you brought them into a new relationship. Once you are in a de facto relationship or marriage, finances can slowly become connected, sometimes without you even realizing it. And that's exactly why planning early is so important. Many people think financial risks only start once you get married, but in Australia, that is not true. De facto relationship can create legal rights after 2 years, and sometimes even sooner. You don't actually need to be married at all for property claims to exist. So if you're thinking about moving in together, planning a future together, getting engaged or getting married, it's really important to think about asset protection before things become complicated. One of the key tools available under Australian law is a binding financial agreement. You might hear this called a prenup or postnup, but essentially it's a legal document that allows couples to clearly agree on what each person owns at the start of the relationship, how future assets will be handled, and what happens if the relationship ends. A binding financial agreement can cover things like property, savings and investments, superannuation, businesses, and even inheritances. For it to be valid, both people must receive independent legal advice. I like to think of it as a roadmap, not because you expect things go wrong, but because you want certainty if life takes an unexpected turn. Let me give a simple example. Sarah is 52. After her divorce, she kept her home and her superannuation. A few years later, she moved in with a new partner. Without the binding financial agreements, over time her home could become part of a shared asset pool. And if they separated in the future, she could find herself back in the legal negotiations again. With a binding financial agreement in place, her original assets are clearly protected. What they build together is clearly defined, and both of them feel safer and more informed. That's not being difficult, that's just being sensible. Now, even when women think carefully about relationship planning, there's one crucial piece that's often missed: estate planning. In Australia, marriage can revoke or alter an existing will. Superannuation isn't automatically covered by a will. New partners may have a right to challenge estates, and adult children can be unintentionally left out. Good estate planning usually means reviewing and updating your will, tracking your superannuation death benefits nominations, reviewing powers of attorney and medical decisions documents, and making sure everything aligns with any binding financial agreements you may have in place. Here's another example I see far too often. Linda remarries at 60. She wants assets to eventually go to her two adult children. She updates her will, but she forgets to update her superannuation nomination. After she passes away, her superannuation is paid to her spouse. The will is challenged, and the adult children experience unnecessary stress and legal costs. This happens more often than people realize, and the good news is it's completely avoidable with the right guidance. If you're repartnering or remarrying, there are some simple steps you can take. Get advice early, before assets start to mix. Consider whether a binding financial agreement is right for you. Update your will and your estate plan. Review your superannuation beneficiaries. Keep records of what you bring into the relationship. And most importantly, have open and honest financial conversations with your partner. Clarity truly does build trust. You've already rebuilt once. You deserve love and security. Protecting your financial future isn't about fear. It's about respecting the life we worked so hard to create. If you are repartnering or remarrying and want clarity around wills protection and long-term planning, speaking with a qualified professional early can make all the difference. If this video helped you, please like it, subscribe, and share it with someone who may need this information. To learn more, visit compoundfreedom.eu, and I will see you in our next video.